The individuals who need lawyers are generally the named litigants in the case. They hire the attorneys, and the attorneys generally hire you as an expert witness. The client is the one who pays both you and the attorneys, so even though the lawyer or law firm may formally hire you, it's a moot point since the litigant is paying for both you and your retaining attorney. When you do meet with clients or those who work with them, or with witnesses, they may have strong opinions about what or who was right or wrong. You should just listen, ask appropriate questions, and take notes that are factual but not opinionated. You should not reveal your thinking to these people or on paper, but only say that you are gathering facts with which to formulate opinions. Hedging in this way protects you from expressing opinions that are not yet finalized. From time to time, you will determine that your client is in the wrong, that he may be the bad guy. You still have to remain calm and neutral. This does bring forth a bit of urgency, however, because if you reach such a conclusion, you have to share it with your attorney as soon as possible. Let the attorney decide what to do with that information. At times, the attorneys may choose to release you from the case because your opinions may no longer be able to help them. At other times, this may strongly guide the attorney into a different tack in the matter. I have been involved in cases where my research proved that my attorney's client was guilty. In those cases, the research helped the attorney to settle the case on better terms in civil matters and plead the case to less burdensome terms in criminal matters. Even though you bring objectivity to your job as an expert witness, it can still be stressful when you cannot help to prove the innocence of your own client or the guilt of the opposing party's client. However, if you have done your job properly, you can still be proud of the professional way in which you performed your investigations and your analyses. In effect, you have helped both the attorney and the client. Regardless of whether your side is in the right or in the wrong, your work efforts can help assist the attorney to obtain a better final result. Now, let's talk about being an attorney's hired gun. At other times, you might need to or choose to actually withdraw from a case. A serious reason for this would be a request from your retaining attorney that you offer a dishonest opinion. While not the norm, some attorneys will only hire you if you agree to deliver the opinion they want. If you are willing to give them the opinion they need and want, then they will hire you. You should not accept a job from any attorney who has that expectation. It's more difficult if this request comes after you have been hired. If and when you discover this, remember it's your reputation at stake. If your attorney wants an opinion that you have not yet reached, you should clarify that it is not ethical and that you cannot do that. Even though your opinion might turn out to be what the attorney wants after appropriate research and analysis, the attorney may no longer wish to retain you as his expert. At this juncture, you could offer to continue working with the understanding that you will only deliver an honest opinion after you review the evidence and complete your investigation. If you are willing to use your reputation and your knowledge to give an opinion that you know is unfounded, untrue, or not fully researched by you, you are simply gambling that the other side's expert won't discover this. During cross-examination, nearly any attorney can make a poorly prepared or dishonest expert witness sound like a fraud or an idiot. Clients who ultimately pay the bills are more sensitive to your expenses than the attorneys. They know that they have to have an attorney. They do not always understand why the attorney has to hire an expert. They do not always understand why the expert receives so much money. So an important tactic to consider is that clients are rarely happy to pay the money that you charge, except when your work is the reason they win. Nevertheless, you have to remain professional, personable, polite, and believable. The client and attorney will want to see these same traits when you testify in court. But for the moment, you are trying to make the cost of hiring you acceptable to the client. In addition, you are often trying to acquire useful information from the client as gently as possible, while not succumbing to pressures the client may bring to bear on you. Conflicts sometimes can arise with clients. For example, the client is frequently anxious for the case to end, frequently anxious to receive your opinions, to learn what you have discovered, and almost always to minimize your bills. You will also feel pressure from attorneys, but you will feel more pressure from clients. So the best advice I can give you here is to spend as little time as possible alone with the clients. Generally, you will need to spend some time in discussions with clients. Just do it, if possible, with the attorney present. Since they pay the bills, many clients participate in phone conversations or meetings that you have with attorneys, although sometimes they will call you directly. The best advice is to say as little as possible to the client, especially if it's at a time when the attorney is not participating in that discussion. The less chatty you are with the client, the better. Although you work for the client in a sense, your job does not require that you develop a personal relationship with the client. It only requires that you receive from the client the information and materials necessary to formulate your opinions. Now, you need to avoid becoming a client's hired gun as well. You should expect that a client may occasionally try to influence your opinion, which should not be surprising. Clients always have a vested interest in the outcome, and they usually have a strong opinion about the rightfulness of their position. The client hopes that you will support their position, and oftentimes expects you to do so. They do not always understand your objective role. Sometimes they just believe that you have been hired to espouse their position. You have to resist this. The easiest defense to this pressure is simply to state that you are still gathering information and that you are still working on your final opinion. Even if you do this, though, you will still hear clients restate their positions, beliefs, and hopes. You should just be polite, listen, but avoid any agreement. Some clients are more subtle than others. They will not explicitly tell you what they want from you or what opinion they want you to express. They may simply barrage you with their views of how things happened, or what things went wrong, or why things worked out as they did or did not. They may express their own opinions about events or personnel or activities, and they may regale you with details that they just want you to hear. When you hear information from a client who pays for your services, you will often hear things that they want you to hear and that they hope will influence your opinion. You will probably not hear all the facts, but only those facts that support their point of view. The bottom line is that while you should listen to what they have to say, you may have to dig deeper to see the rest of the picture. You have to find out the relevant facts, but what the client or his attorney tells you may only be a portion of those facts. Keep looking. You should ask for additional documentation about any incomplete information you receive. Asking your attorney and client for additional details and information can save you the time or cost of finding it. If you cannot obtain what you need directly from your client or attorney, you should then look further and continue your research and investigation with other sources. If you do the work and spend your time diligently, you will not have a problem. In court, hired guns are not as likely to have done the research and thereby have the details to defend their opinions effectively. Word gets out about which experts, even if credentialed and knowledgeable, will sell their opinion just for their consulting fees. The term hired gun is demeaning, and it's just not a term that you will ever want to hear applied to you.